So when is a party discharged from their obligation of performance or they no longer have a duty to perform? Well, as we talked about, you can completely perform your obligation under the contract. In that sense, you've done all the necessary activity and you are excused from performance. You can substantially perform. That is, you do all of the material aspects of your obligation minus some minor things. And again, your duty to perform is excused. Another situation is if you tender performance or you attempt to perform and the other party rejects your reasonable tender of performance. In that situation, again, you are or could be relieved from your duty of performance because you have attempted to perform and you haven't been able to. And lastly, say you have a divisible contract or a contract that has multiple parts to it, each of which can be completed independently. That's typically called a divisible contract. You can complete individual parts of that contract and be excused from that portion or the performance of that portion of the contract. So failure to do another portion is not complete breach of the contract. It is just breach of that small portion that you failed to complete. And then we have a doctrine of fairness that says impossibility or impracticability of performance can also relieve your responsibility. Now, we deal with impossibility and impracticability in a different lecture video. So take a look at that lecture. But generally, these are the manners by which a party is discharged from their duties or obligations under the agreement.